Good morning. I'm not very well, so I got check-up by the doctor, so I got late.
For admission, items 1 and 2.
Lordship, as directed by Lordship, I have submitted written synopsis and copy of same was submitted to my learned.
Acha, okay.
Lordship, while preparing the case yesterday, I find out
This is the matter, item number 1?
1 and 2. This is a contempt, Lordship. Yesterday, Lordship heard the matter.
Oh, this is the same one?
Yes, same.
Yes. Item number, yesterday, that was 3 and 7?
Yes, 3 and 4.
Yes.
So I have
No,
submitted.
I had gone through to a certain extent. What I find is, if you can just answer the queries. First of all, the direction was to conduct a spot verification and thereafter do the needful assessment,
Yes, if
everything.
they are entitled, then the compensation should be paid to them.
That was in the year 2014, right? And the order was 13. Order was when 30/4/2014.
Lordship.
30th of April. But after that, the CVC meeting was held.
Yes.
It was constituted and a meeting was held.
Lordship.
But there was no spot verification as such.
Lordship,
Right.
yes. Lordship.
They said that spot verification was not possible in
Yes.
one of the affidavit.
Yes, Lordship. And Lordship, our contention is that the recommendation was made sitting in the office. And even the...
That cannot be done. You have to go to the spot and verify.
Lordship.
And this one query is that there was no spot verification as such. They say it was not possible. And in the impugn order, of course, it was said that if spot verification was already done, then there is no
it is not
requirement.
required. Yes, correct.
First is that. Second is that from 1966 to 86, there was no record.
Yes, Lordship.
There was no record, and so they cannot say whether the land was under the
Occupation
armed
of the
forces.
Armed forces.
And the blueprint thing came only in 90s,
91, 92.
91,
and
92.
subsequently in 2009.
And thereafter,
In
they
2009.
say that it was not within the blueprint area.
Yes, it is contention of the respondent.
That has been taken. But from 1966 to 86, there is no record,
There was no
nothing.
record. Yes.
Right. And from 90s, you say that it is not within blueprint area.
Yes, it is our contention.
It is outside. And one more thing, during the impugn order, central government was called number of times notices were issued, but they did not appear. Last Mr. Barbhia appeared, he wanted time, but it was refused.
Lordship.
Right. So those things could have been placed that time.
Yes, Lordship, yes. correct.
But it was not placed.
Yes.
And so, first thing, the first order is not followed. Spot verification is not done.
Yes. Minutes, we have annexed some minutes.
It is a minor of the meeting.
Yes, Lordship.
This is verification committee's meeting minutes.
Lordship, yesterday I have come across one judgment of Honorable Supreme Court, recent judgment. Lordship. Paragraph 17 and 19 of that judgment. It is a judgment dated 19th of August 2025.
And even before extension was granted,
Lordship.
right, those facts were not brought before the court.
Yes.
Even though those letters were before the extension was granted, DEO's letter and all. Those were not placed when the extension was granted.
Probably it was not placed. Lordship, paragraph 17.
Yes,
merit.
17.
Paragraph 17. In Ashok paper, Kamgar Union versus Dharam, Goda and others, this court held that the contempt jurisdiction is intended to uphold the majesty of law and not to settle personal grievances. Similarly, in case of Ram Narayan versus so-and-so, in case of civil contempt, the breach must be deliberate and intentional. Then paragraph 19, last 4 lines. In Janesh, bold Lordship, in Janeshwar Prasad Paul and another versus Tarak Nath Ganguly, this court held that contempt proceeding cannot be used to circumvent proper adjudication mechanism. Accordingly, the prayer for pension cannot be entertained at this stage.
You are right, but then you are admitting that there is some contempt, but then not willful.
Yes, Lordship, that is our contempt. That's why I think it proper to place before our Lordship.
But how can I consider it is not willful? Because even before extension, this was not,
No,
those
Lordship,
things
here,
were not.
Lordship is to see what was the direction of this noble court. To constitute a joint verification team, and if they, that joint verification team if found that they are entitled to lender compensation, then it should be paid, and if not.
No, CD impugn order.
Yes, Lordship.
Hey, Michael, just help me out. Give me the contempt application. Yes, thank you.
Page number 13 onwards.
Huh. So here, you see the directions, right?
Lordship.
So first, joint verification team to be constituted with these members.
Lordship.
Right. And then you see, this read is disposed of with a direction to the respondents to make a spot verification
Not
to ascertain whether the petitioner's land are in occupation with the forces.
Yes,
The joint verification of the land of the petitioner shall be done by a committee.
Lordship.
So the spot verification was ordered,
Lordship, some
but
right-
no spot verification was done.
Lordship, rider is also there. Once some rider is also there. in that-
Rider is there only if it is found.
It is, if it is found. Lordship.
No, as far as spot verification, no riders.
Yes, Lordship.
Huh.
It is,
Then-
it is mandatory.
Joint verification team so constituted shall verify the lands of the petitioners to be under the occupation of the forces and shall thereafter furnish all details
Yes, Lordship.
to the appropriate authorities.
Lordship. Then it was, direction was to the respondents to made spot verification, and report of the committee should be, if they found they are entitled to compensation, then it should be paid. Lordship, here, we have annexed the minor clause in contempt number 1. Lordship, page 7, annexure 1 of my affidavit dated 24/7/24. I have, Lordship, written in my synopsis also,
Wait, your affidavit dated?
24/7/24. Additional affidavit filed by Ajay Bhala, Lordship, Division Home Secretary.
24/7/24. I thought the one you placed yesterday?
Yes, yes, Lordship.
So what did you say? It's in your note?
Lordship, report dated 23rd July 14. Lordship, there was a objection raised by the MHA as well as by the DU.
That I have seen, I remember.
Yes, Lordship.
The MHA and the DEU had raised objection.
Yes. And Lordship, yes, it was signed by us, but DO didn't sign. So Lordship, when joint verification report is to be to be accepted by all the stakeholders, Lordship. Here it was not done.
But see the objection raised by the
Yes, ma'am.
MHA and
Yes.
DEO, those objections were again not placed during extension?
Lordship, it was
It was
earlier.
after extension?
It was after extension, Lordship.
Before.
It was,
There are so many affidavits are
it was raised in joint, minor, Lordship, dated 23rd July 2014.
In your minor, in your what?
In affidavit, additional affidavit filed by Ajay Bhala, the then Home Secretary, Lordship.
Wait. Show cause reply, list of cases. Then this is the petition. Judgment. This is show cause reply.
Probably this is the affidavit.
There's the one, right?
Yes.
See here,
Annexure 1, Lordship.
Annexure 1. This is this is MHS few few objections by the MHA.
Lordship.
CD objections.
One,
Presently,
presently-
the claim lands are not in occupation
Yes.
under the security forces and it is outside the blueprint area. This is by way of that map.
My notes, they are
Map.
raised, yes. Blueprint is the map. Lordship.
The basis is blueprint map.
Yes, Lordship, this objection was read in the, my notes prepared by the joint verification team. At that time, it was both MHA, representative of MHA, as well as DO raised the objection, Lordship. And Lordship, may please to see next page.
Oh no, I'll go one by one. That the DEO Guwahati should furnish a certificate as to whether the lands were actually occupied by security forces during 66 to 86 or not. If lands of petitioners were actually occupied during the said period, then spot verification should be conducted. Concerned authority should verify whether these petitioners have not been paid. Okay, out of the, okay, 1995.
95.
Then comments of DEO. Land of petitioners falls outside blueprint as demarcated. The survey carried out on 2009.
Yes, Lordship.
During the survey of 2009, it was found that it was away from the blueprint area.
Yes, Lordship. Then B,
As per the board
Board's
proceeding,
dated 7th.
the actual area, as per the board means which board? Proceeding
Lordship, it is,
2005.
probably it was considered by the state government, Lordship.
The actual area occupied is 54 acres.
Yes, Lordship.
However, as per sanctioned area listed under sketch map, the area for which rental compensation is given is only so and so.
36.18.
So what does it mean?
Lordship, earlier the area was 54.380 acres.
Actual area occupied
Yes, Lordship.
by the petitioners.
No, Lordship. Total area.
No, the
By
owned.
other petitioners also. The whole area of that.
Whole
district.
area,
Lordship.
which is said to be under the forces.
Yes, Lordship.
That is 54.33,
Yes.
0 acres.
But in 2009, the sanction area listed under sketch map of 19th and 30th June, area of which rental compensation is given is only 36.18.
So rental compensation is already given during
Yes,
2009.
Let's see what happened during insurgency. When insurgency was over, there was the agreement between government of Mizoram.
That I have seen.
Then let's see 15 crores was sanctioned. But thereafter let's see different orders had passed and spot verification was conducted and as per report, the committee found the actual person whose land were occupied by the security forces, used by the security forces, they were paid compensation. Lordship.
In 2009, after.
Thereafter also. Till Lordship, still we are paying. Last year also we have paid to some.
Where the petitioners also have their
No,
land?
not petitioner,
Not,
other
other
persons.
persons.
Yes, Lord.
Okay.
And
Due
two
to
or
this
three-
variation, there is a need to redemarcate the existing blueprint area of the map prepared in 2009 by using high-tech equipment.
To ascertain whether the land actually lies within the blueprint area or not.
So there is a need to redemarcate
Lordship.
by using high-tech.
Yes.
So
Lordship,
again, about the passes, there is again an objection that village council cannot issue
yes.
passes.
Yes, Lordship.
And
That
because
was,
of that, they don't have the ownership of that land.
yes, that was held by this honorable court in 2015 itself.
Some land are also with regard to that.
Yes.
Some land of the petitioners.
Yes, Lordship.
So they cannot claim.
They cannot claim compensation. On conjecture surmises, rate and compensation cannot be given to them unless it
Those
is.
facts were not placed before the,
Yes,
during the writ proceeding.
Lordship, because simple order was passed to verify the land, but it was not undertaken. And when Lordship, all the stakeholders should be unanimously come to a conclusion that the land of the petitioner are used or occupied by the security forces during the relevant period.
Then on verification of land petitions, you see,
On further discussion, physical verification of the land of the petitioners were considered not necessary.
Not
on the-
necessary.
On ground that the verification was already conducted by the previous joint verification team, and the land of the petitioner were included in the map prepared in 2009.
So no spot verification is required.
Yet it is the
is
finding
D.
of the other stakeholders of the state government. Then the land of the petitioners are laying outside the blueprint area, that is the actual occupied area of 2009 and onward. It is just adjacent to the blueprint area.
Just
So
adjust.
they have admitted that it was outside the blueprint area. They said that it was adjacent to the blueprint area. Then C, the land actually occupied by the armed forces cannot be clearly ascertained for the period between 1966 to 86. It must, however, have been larger than the presently occupied area as shown in the map prepared in 2009. Moreover, it must have been affected by occupation of neighboring land, and access and use of land would have not been possible at the point of time. Then Lordship, in conclusion is very important. Therefore, member of the Additional Secretary Revenue and Deputy Commissioner of the verification team propose payment of the rental compensation to the petitioner for period from 1966 to 86, and the assessment is prepared as such. The other members, that is representative of Assam Rifle and DO Guwahati, do not agree to the payment of rental compensation, and they have submitted their comments at point number 1 and 2 respectively.
So even 66 to 86, Assam Rifles objects.
Objected because the land was found to be outside the blueprint area, and it is a finding of the representative.
But there is no map that time.
Ye-
You
Lordship,
cannot say that it was
The
outside.
2009 map was there, and it is Lordship in B. The land of the petitioner are laying outside the blueprint area, that is the actual occupied area in 2009 and onwards. It is just adjacent to the blueprint area. It was not within the blueprint area, it was adjacent to the blueprint area. So the state officials, they think to recommend for payment, Lordship. Whereas the representative of Assam Rifle and
They
MHA,
object.
they objected, Lordship. So in view of Lordship, whether there is any contempt committed by the present petitioner, that is to be looked into by your Lordship.
There was a memorandum of settlement also in 86
Yes,
for
Lordship.
rental charges to be paid, right?
It was about 15 crores at the relevant time, Lordship. But subsequently it was increased to probably till date, Lordship, 150 crore has been paid to different petitioners.
The first map came in picture on 1993.
91, 92, Lordship.
93,
Lordship.
first map. Before that, there was no map.
Yeah, there was
We
no map.
cannot say. When was the extension given? Which date? Yes, Mr. Victor?
29/6/2015.
Uh-huh.
29/6/2015.
29/6/2015.
Yes, my lord.
See, extension was given that time. And before that, December 2014, DEO wrote to Mizoram government that land falls outside the blueprint area,
Lordship.
right? Then on February 2015, government of Mizoram was informed land of petitioners outside the blueprint area prepared in 93, 2009. However, DEO's clarification could not be placed. Extension applied for. An extension, nothing is said. They
Yes.
simply said, we will follow and then
Court's
give
order.
me. And then rental compensation based on village council passes not admissible
Yes,
because of Rule 3 of Lushai Hills District.
Lordship.
And what about this, there is an affidavit by R1 saying that government of Mizoram, I don't know, it was informed to them, I think, petitioners were granted periodic patta in 2006, immediate release of 1.05 crore, and it was also stated that the same may be informed to the court. That was also not done.
Lordship, yes. Lordship, what happened in another case, I don't remember the number of the case. In this case, about 66 persons filed application for seeking compensation. The matter was referred to CBI. Then Lordship, half of the persons were evaluated, they were not actual owner of the land. That was also, so it was while granting compensation, all these things are scrutinized by the Ministry of Home Affairs as well as the state of Mizoram, who are in actual possession of the land. Lordship.
But the fact remains, those facts you had not placed
No,
even
Lordship.
during the,
No, no,
forget
just not-
about placing during writ proceedings, you did not come. And secondly, before extension, nothing was placed.
Lordship, that,
Now, after so many years, you say that,
No, Lordship.
and this stand was taken long back.
no, Lordship, here, Lordship, dealing with the contempt proceeding, Lordship. So here we have placed all the materials for consideration of your Lordship. In contempt proceeding, probably the latest judgment says that even delay cannot be a ground for, Lordship, may I place Lordship this
Yeah, the
judgment?
requirement is that willful and deliberate
Yes,
violation.
that is the rule by the Honorable Supreme Court many
That
times.
is settled, willful and deliberate violation.
Now Lordship
Of course,
is,
there is a rider that only if their land falls,
yes,
for what, only if their land were occupied by the forces.
for the forces.
Only then they are entitled for
Entitled to
compensation. But then you did not place it in the right time, at right time. But then, whether it is willful or deliberate, that has to be considered.
Lordship may decide all these things.
What do you say, Mr. Victor?
My lord, to
He
clar-
has filed one written submission, have
yes,
you?
I have seen, my lord.
Do you-
To clarify one point, my lord,
Huh.
I have the copy of the application for extension, my lord, wherein they have enclosed the meeting minute which my land friend is referring again and again. So all this was already considered by this honorable court.
Acha,
While
during
granting the-
extension, those were placed.
Yes, my lord, it's enclosed. That meeting minute was placed
Ha.
in the application, my lord.
Acha. But then that learned judge said that those are not to be considered at this stage or something, right?
Yes, my lord. Moreover, my lord, the only reason,
Where is the extension order? Yes, I've got it. Here, yes, in the first place itself, right?
yes, my lord.
Rectification of the objection is necessary. Question of converting the land passes to periodic patta is not bird and so and so. Okay. Then, objection raised by the Ministry of Home Affairs. Cannot be considered and allowed by way of an interlocutory application, and this is an internal matter between the applicants and the state government. Yes, Mr. KL, that was actually considered. And it is said that it is between them, and this cannot be considered by way of this IA for extension.
And one more point, my lord, if your lordship may kindly allow to revisit the order dated 30/4/2014, page 13, the order of the, in the writ proceeding, my lord. The order of the writ court.
Which para? There are no paragraphs, you can just say page number.
From page number 13, my lord, I'll read it out quickly again for my own benefit, my lord.
No, you have to answer whether that is a willful and deliberate violation.
I'll address that, my lord, after going through this. Page number 13. Heard Mr. So in a number of occasions, opportunity was given to the central
That I
government.
have seen.
Yes, my
They
lord.
did not.
Yes, my lord.
And Barmia came and he wanted time, but then
Page
it
number
was not.
15. Page number 15, my lord.
Page number 15.
Yes, my lord.
Yes.
Mr. H. Babuya, the learned CG submits that verification of the lands of the petitioners has already been done, along with other persons, and thereafter assessment is under process. He therefore submits that no further verification of land is required as regards the land of the petitioners. And At
So
page
he
number
said
16,
verification not required.
not
Yes.
required because it was already done and assessment was already under process.
Yes.
That is the submission of the learned CGC. And my lord, in this para 16, the last para, this court, the honorable court, had held that in the event the lands of the petitioners have already been verified as submitted by the learned CGC, no further spot verification will be required. However, the process of assessment and payment thereafter should be completed within such and such period. So, my lord,
No spot
there is no such requirement for conducting further spot verification in this case.
So no spot verification? It is already done because.
Yes, my lord, as admitted by them.
Huh.
And whatever the submission or whatever the records in the proceeding, my lord, the respondents have not filed any appeal or review at any point of
that is
time.
there.
This had attained its finality. And when the meeting minute, which my learned friend has been placing again and again, was held on 23rd July 2014, and thereafter, the extension application was made enclosing the said minute. And the main query raised by them was regarding the conversion of village council pass into PD Pata, which was decided by the learned judge in the extension order. That,
So just let me know one thing.
yes, my lord.
One point is that the village councils cannot issue passes for agricultural purposes to anyone, although they can allot places to others. Or to that extent, okay, because there is no provision under the Lushai Hills Rule 33 or something. And what about this periodic patta again? The passes are converted to periodic patta?
Yes, my lord.
Same passes.
Same passes, same plot of land.
Then what happens? If it is converted to periodic patta, then one can own.
Yes, my lord. And regarding that, my lord, this order dated 29/6/2015, page number 19.
Where it is said that passes cannot be issued.
The question of converting the land pass into PD Pata
Where
is not
are you reading? Where is that?
page number 19 of my contempt petition.
Page number 19. Acha.
In the extension order, this has been
Yes,
ruled
yes.
out.
That I have seen.
Third paragraph, my lord. The question of converting the land passes into PD Pata is not barred under law, unless the same is barred by law or land acquisition laws, for which a prior necessary notification has to be issued by the competent authority before acquisition of land. The applicants, central government, have not produced any law or rule which bars the conversion of pass into PD Pata while it is occupied by person other than the landholder. The present case relates to verification of land for the payment of rent only. In any event, the submission of the land at CGC with regard to subsequent conversion of land pass into PD Pata cannot be a subject that can be dealt with in this application. As such, the prayer of the land at CGC with regard to giving direction to the government to rectify the objection raised by the ministry cannot be considered and allowed by way of this interlocutory application, as this is internal matter between the respondents. So, my lord, both this order in the writ petition as well as this extension order has not been challenged by way of appeal or otherwise, my lord. This has now attained its finality. And even though the verification report has been addressed by my learned friend, the conclusion which can only be arrived is that it was under the occupation of the respondent authorities. Blueprint is blueprint, as submitted by my learned friend yesterday. But it is undeniable that it is under the occupation of the respondent authorities, my lord. And time and again,
Blueprint is itself and the area which is under the occupation of forces,
which was changes from time to time.
which changes from time to time.
Yes, my lord. And prior to 2009, my lord, it is an admitted fact that the actual occupation of the respondents was much larger than the present day. And
Was much larger than.
much larger, my lord. And it is also admitted that the land of the petitioners lies just adjacent to the blueprint as on 2009.
Yeah, that is said.
And moreover, in the order dated 30/4/2014, passed in writ petition, my lord, it was already submitted and admitted by them that it was under the occupation of the armed forces, my lord.
No, that is said that if it is under the armed forces, then payment.
Yes, my lord, exactly, my lord. So we cannot examine the rightness or wrongness of the order or the submission passed therein, as held by the Honorable Supreme Court. Do I have to submit the?
Now CGSC said that spot verification already done in 2009, not required.
Not required.
Right, and so they have to just assess and pay the money. But again, he is saying that because there is a rider, only if it is under the occupation of forces.
And that was already admitted by them, that it is under their occupation. Para 5, my lord. May I read? While dealing with an application for contempt, the court is really concerned with the question whether the earlier decision which has received its finality had been complied with or not. It will not be permissible for a court to examine the correctness of the earlier decision which had not been assailed and to take a view different than what was taken in the earlier decision. A similar view was taken in the case of such and such. The court exercising contempt jurisdiction is primarily concerned with the question of contumacious conduct of the party who is alleged to have committed default in complying with the directions in the judgment and order. If there was no ambiguity or indefiniteness in the order, it is for the party concerned to approach the higher court if, according to him, the same is not legally tenable. Such a question has necessarily to be agitated before the higher court. The court exercising contempt jurisdiction cannot take upon itself power to decide the original proceedings in a manner not dealt with by the court passing the judgment and order. Though strong reliance was placed by the Land Council for so and so, we find that the same has no application to the facts of the case. In that case, the question arose about the impossibility to obey the order. If that was the stand of the state, the least it could have done was to assail correctness of the judgment order before the higher court. The state took diametrically opposite stands before this court. One was that there was no specific direction to do anything such and such, and second was that which was required to be done has been done. If what was to be done has been done, it cannot certainly be said that there was impossibility to carry out the orders. In any event, the High Court has not recorded the findings such and such. And para 8, my lord, para 8.
But then this is a different situation. Our case is different. Here, on spot verification, they have to find out whether the land falls.
But in the order of the writ petition, my lord, they have already admitted that it was already verified and included in the occupation, my lord. So they cannot change their stand.
No, that exactly was not said, that they have verified and the land falls within. That, in so many words, it is not there. It is 2009 verification is done, so no verification required. Right.
Yes,
that
my lord.
implies, of course,
Yes, my lord.
that no verification requires and these falls. But in so many words, it is not there. That the petitioner's land falls within the, has been in occupation by the forces.
It is in the submission of the land CGC in the
That of course we can drag it.
Yes, my lord.
That way.
That is what I mean to say. They cannot change their stand what they have submitted in the writ proceeding, right or wrong, unless they challenge the said order, my lord. So, my lord, at this stage, my lord, your lordship may be kindly pleased to pass an appropriate order. Either they will be paying the assessment as it is, or else will be facing the punishment prescribed by the Contempt of Courts Act under Section 12, my lord.
Okay. Can you give me a written argument or some synopsis?
Yes, my lord.
When can you give it?
During the course of this week.
Okay. This week means before Friday you give?
Yes, my lord.
Saturday I will write down. Okay. And what about your? I could not go through your case yesterday.
It's slightly
I was
different.
really feeling bad.
Your Lordship, this case is slightly different. In fact, it is more straightforward.
Let me.
It is more straightforward.
Acha.
I would like to first come to the judgment and order.
Just let me
I apologize.
take care of these papers.
Of course, Your Lordship.
This is by Victor. For item 2. and, okay, 1 of 10. This is by KR. Okay. Yes. नहीं खाया नहीं खाया नहीं हाँ yes
Yes, Your Lordship. First of all, I would like to take Your Lordship to my contempt petition, particularly at page 22, annexure 2. This is the judgment and order which we are alleging that it has not been complied. Before I come to this judgment and order, Your Lordship, if Your
One
Lordship,
second.
oh, yes,
Yes. Which page you want me to look into?
page 22, annexure 2.
Page 22, yes.
This is WPC 8 of 2010. This was disposed of on 3rd 3/3/2011. Now, in fact, as far as these petitioners are concerned, there were as many as 26 petitioners. This is the second round of writ petition.
Acha.
What happened was that initially, everything is mentioned in the judgment in order, so I'll just quickly summarize it. Initially, as many as 29 petitioners joined hands and approached this court and filed WPC 62 of 2007. 62 of 2007. This was disposed by judgment and order dated 7/1/2009. The prayer was the same. Our land is under occupation. Please have a spot verification. If yes, please pay. So a joint verification team was formed, which was headed by the Deputy Commissioner of Lunglei District.
That order you have annexed?
Everything is there in the judgment and order itself.
Oh, it's-
Everything is reproduced.
Okay.
So, based on that direction of this honorable court in that writ petition, verification was done. 3 persons were approved, while the remaining were rejected on the ground that they fall outside the blueprint area.
Acha.
As
So
such,
3
being a
petitioners' case was
allowed,
allowed.
and the remaining were rejected. So that's why we, on the ground that we were out, most of us were outside the blueprint area prepared in 91 and 92. So we approached this honorable court again,
What about 86 to 96?
66 to 86 only, same.
66 to 86?
Yes.
66 to 86, there is no report, there is no map.
Yes, so the verification, because during that time, during insurgency, all the proper land documents were was kept with the DEO, DEO Guwahati. They have all the land passes. Anyways, Your Lordship, just moving forward, after the spot verification was conducted by virtue of that WPC 62 of 2007, a joint meeting of the joint
Spot
verification.
verification was done that time.
Yes, wherein only 3 persons were approved. The remaining were discarded on the ground that you were outside the blueprint area. So, the joint verification team was held a meeting on 17/7/2009. If Your Lordship can kindly turn to page 29, para 6 of the judgment and order.
Yes.
May I read, Your Lordship? Another meeting of joint team was held on 17/7/2009 under the chairmanship of the Deputy Commissioner Lunglei. The minutes of the said meeting approved payment of rental compensation to Mr. So-and-so and so-and-so and with another person whose land situated at Komzol out of 29 writ petitions in WPC number 62 of 2007, since their lands were found to be inside the blueprint area prepared in 92-93. It is contended that though the joint team did find many of the petitioners' lands in occupation of the armed forces and were entitled to get rental compensation, the representatives of the 40th Battalion Assam Rifles did not approve any area beyond the blueprint prepared in 92-93 for the rental compensation, even though the said lands were occupied by the armed forces. In para 3.4 of the meeting,
Even though the said lands were occupied.
occupied.
So there is a difference between blueprint and the lands occupied.
So that's why we approached this, we had filed this WPC 8 of 2010 again.
Huh,
You
what?
cannot shy away from your responsibility just because my land is situated outside the blueprint area, despite the fact that you are admitting that it is under occupation by the security forces. So, Your Lordship, I'll just read this para 3.4 of the meeting minutes, which is reproduced here.
Wait, reproduce, just mark it. What do you, prepared in for?
That,
rent,
the one
even
which
though
is highlighted.
The said lands were occupied by the armed forces. So in that case, his argument goes that blueprint.
The question of blueprint area, they cannot raise it again now. That's what I'm trying to impress upon this court.
Then,
So I'll just read this bold
minutes.
version, the bold portion. In this connection, it may be mentioned that the occupied area of defense forces, since insurgency was verified with the help of previous approved blueprint indicating the occupied area of defense force as 54.33 acres only. Moreover, members of the task force from 48th Battalion Assam Rifles made it clear that they couldn't approve any area larger than the approved blueprint as it was approved by the competent authority. But if reliable and genuine documents can be shown and produced, it may be reviewed and re-verified later. They added, it means there is no any extension of defense land from the previous map which the petitioner claimed that it was wrong. However, it was found even during spot verification that some lands presently occupied by 40th Battalion Assam Rifles falls outside the occupied area for security forces as per this approved map. For example, Dal Rotanga So and So, Lunglei lands falls within the firing range area, although her land is excluded from the occupied area of security forces as per approved map. So these facts were placed on record. So keeping in mind the meeting minutes of the joint verification team, which I have read out, the judgment and order was passed in WPC 8 of 2010, wherein the specific choice of word of this honorable court was if it is found to be under occupation, regardless of whether it is inside or outside.
the blueprint area.
We are not concerned with the blueprint area. If you occupy it, you have to pay. That was the finding of this honorable court. That's why the choice.
In that case also.
In that case also. That's why what I'm trying to impress upon your lordship is that the issue of whether it falls within or outside the blueprint area has already been taken care of in the previous rounds of writ petition. And that cannot be raised again as one of the grounds in a contempt petition especially. That is number one, your lordship.
Which has been decided in this writ petition 62.
In 8 of 2010.
Or 62 of 2007.
62 of 2007 was our first writ petition, wherein the verification allowed 3 and rejected the remaining on the ground that they were outside the blueprint area.
So out of 29, only 3.
Yes. So that's why we were aggrieved, because the joint verification team actually said that there are many lands falling outside the blueprint area but also under occupation. That's why we filed another round of writ petition.
Acha.
So
After
that's
62.
why. Yes, Your Lordship. This 8 of 2010 was filed due to
Wait,
the
what is the number? 2010?
8 of 2010. The present petition is arising out of this 8 of 2010. So that is the case, Your Lordship. We are not bothered with blueprint anymore. That has been taken care of by this honorable court in this judgment and order. Now, secondly, Your Lordship, slightly different from the previous case is that if Your Lordship can kindly turn to page 39, Annexure 5, which is the meeting minute of the joint verification team.
The one which is mentioned there, in the earlier order. Page number?
Page 39, Annexure 5.
Acha. Yes.
So, pursuant to the judgment and order passed in WPC 8 of 2010, this verification was conducted, and this is the meeting minutes reflecting all the details. So, at serial number 1 at the bottom, I'll just read again, Your Lordship, if Your Lordship can kindly bear with me. The joint team of officers had approved the map of Army paramilitary forces occupied area at Komzol as duly countersigned by the Major so-and-so, representative of Assam Rifles, N.R. Das, representative of DEO, Guwahati, Colonel so-and-so, representative of 40th Battalion Assam. It was decided to conduct spot verification of the occupation of private lands based on the approved map. Members of the joint team conducted spot verification. So in our case, spot verification was conducted.
In
There
that
is-
case, it was said that it is already done.
Yes, so that's why the slight variation is there. So that's why in this case, spot verification was conducted. They asked for certain, they sent certain communications saying that please give us a certificate saying that rental compensation have not been paid in respect of these particular lands. Now, at page 53 is the certificate.
Then after that, what happened after conducting this spot verification?
After conducting this spot verification, if your lordship can kindly turn to page 43, which is horizontal. This is the assessment sheet. Now, as your lordship, I had pointed out earlier, in the affidavit of the Assam Rifles, filed in 2014, they were disputing the verification report saying that high-tech equipments were not used. It falls outside the blueprint area. Basically, they're questioning the veracity and validity and genuineness of this verification report. But what is very, very surprising is that in page 43, payment has been made to this serial number 5.
Acha. Number 5.
Number 5 has been paid as per this same verification report.
Why then 1 to 4 are left out?
Correct. So how can you say that we are accepting this portion, we are accepting that portion? Because they have not submitted any clarification as to why only 5 was approved and the remaining portion, the remaining members were excluded. Now, in 2014, as I read out
Otherwise,
earlier.
in the earlier round of litigation,
Yes,
only 3 were approved.
Only 3. That was in 2000.
Huh?
That was in 2007.
7.
Yes.
That only 3 were approved, now 5.
Yes.
After spot verification.
Yes. So out of 5, based on that same very verification report, they're paying 1 person, but they're saying that 1 to 4 you're excluded. And they cannot be allowed to blow hot and cold. Either you accept it or you don't accept it at all. Because and another point that I would like to raise is that which I've already placed yesterday, as mentioned in 2014. In 2014, they filed this affidavit, reply affidavit. This is filed by Sasindram CK.
By
Sasindram CK, 2IC Assam Rifle.
Assam Rifles.
Yes, 27. This is affidavit is filed on 27th of June 2014. At pagination is not given, but this is under para 3C.
By respondent number?
It's not written. There's so many incumbents. They were being pleaded during the course of the trial.
Okay, I'll see it later, you can tell me.
Out here, Your Lordship, his reply is basically that in reply to para 10 of the contempt petition, the answering respondent submitted that on 2nd May 2013, joint verification was carried out. So they admit that verification was conducted. He's saying that verification was carried out without high-tech equipments. It was constituted as spot verification as per the earlier map approved. That is there. Minutes of the meeting were prepared by the district civil administration and not even consulted with the representative of this unit. After all, this decision recommendation as mentioned in the minutes were not discussed and were prepared and forwarded to higher HQ by them with the attendance sheet instead of signed copy. Now, again, what I'm trying to highlight is that they are disputing the verification report. But you have acted on that verification report.
And you paid 1.
Correct. So this is nothing more than a willful and deliberate non-compliance. The reason why I'm saying is that in the so-called clarification submitted by my learned friend yesterday, it's a reproduction of this same affidavit of 2014.
I've seen in the affidavits the same thing.
If that is not willful disobedience, then what would constitute willful disobedience? Number one is that they, for the first time, as far as my knowledge goes, going by this affidavit, verification report was prepared in 2013. They disputed the verification report in 2014. If that is the case, then why didn't you challenge it? They sat over their rights, kept quiet, and saying that, oh, nothing doing, we're not going to pay, we're not going to comply, we'll just dilly-dally the matter and play cat and mouse with the court. This has been delayed for what, more than 15 years?
The directions were same in your case
Same,
also?
same.
Like in the other case?
Yes, Your Lordship, same. But the difference in my case is that spot verification was actually conducted.
done.
And that is an undisputed fact. And coming to the affidavit of...
So you are claiming rental compensation
As per
for
the verification
these
report.
5 persons?
no, 4, because
Yes,
5
one
has
is paid.
already paid.
4.
Yes. Now, coming to the affidavit of Mr. Ajay Kumar Balla, the previous incumbent holding the position of Home Secretary. This affidavit is dated 26th of July 2024.
26th of?
July 2024, as per the signed affidavit. At page 4, again, it's basically a reproduction of that same thing, saying that they are disputing the spot verification because high-tech equipments were not used. But the reason why I've highlighted this is just to mention the fact that at page 6, serial number 11,
Which affidavit?
same, Ajay Kumar Bhalla.
Ajay Kumar Bhalla.
He was the previous Home Secretary.
Dated, you said 2024.
Yes, Your Lordship, 24, very recent.
Affidavit which was, I relied on Lordship.
Same thing,
Yes, Lordship, same.
as in the other case.
Yes.
No, but
No,
there's...
Lordship, affidavits are different in both the cases.
No, but in the
Same date. Date is
annexure
same.
is same.
Yes, Lordship.
No, connection.
Yes.
Your Lordship has it?
That's one number 10. Okay.
Yes. So at page 4, serial number Roman 4, again, they're disputing the spot verification, saying that they were not properly consulted, so-and-so high-tech equipments were not used. Same thing. But what I would like to stress on Your Lordship is at page 6. At the bottom, para number serial Roman 11.
Yes.
The Ministry of Home Affairs, Government of India has released a sum of so-and-so for payment to petitioner number 17 for the period from so-and-so. This is the name reflected at serial number 5 of the verification report.
For payment of to petitioner number 17 is that number 5?
This is the petitioner number in the writ petition.
Otherwise number 5 in the verification?
Yes,
Acha.
one and the same person.
For the period 1st Jan 1967 to 86?
Yes, as assessed by the DC. So
Whose
now,
land was found occupied by the security
so
forces?
this was paid in the year 2014, Your Lordship.
Yes.
2014 it was paid. So after a period of 11 years, how can they say that we are questioning the spot verification when you have acted on that same report? They have not denied conducting spot verification report. The report was approved, was prepared on the basis of a map duly approved by them. They have made payment based on that verification report. Especially in a contempt proceedings, how can they raise all these things when they haven't challenged the verification report, they haven't challenged the judgment and order passed in the writ petition, and they are reiterating the same grounds after a period of 10, 11 years without giving any new facts or circumstances. So what is preventing them from making the payment unless, if this is not willful disobedience, Your Lordship, nothing else will constitute willful disobedience. As such, my humble prayer in this particular case is that either they pay or they have to face the music as per the Contempt of Court Act. They have not brought out a single new facts or circumstances. It's the same thing.
Okay, Mr. Kayal, please give me one written
I shall do
submission.
that, Your Lordship.
I'm relying on the affidavit, Lordship.
No, what I want an answer from you is
Lots.
blueprint area and the area occupied by the forces are different.
Yeah, different, Lordship.
They are different.
Yes.
Then in that case, you cannot bring that blueprint area thing here.
No, Lordship.
They are outside, adjacent,
No,
all
if
this.
it is found to be outside, then they are not entitled to rental
That
compensation
issue is no
from the-
longer res integra in
Then
this
again,
case.
you are saying the same thing.
Lordship, my affidavit is very clear. My learned friend also submitted, Lordship. I request him to, when I am listening to him, I didn't interpret.
Okay, he will not.
Lordship, paragraph 11, my learned friend placed before your Lordship, that the Ministry of Home Affairs, Government of India has released a sum of rupees 29,25,000 directly to the Government of Mizoram for payment to petitioner number 17 for the period from 1st January 1967 to 31st August 86, whose land was found occupied by the security forces to be taken by the state government as per direction of the Ministry of Home Affairs. So, Lordship, his land was found to be occupied by the security forces. That's why he was make payment.
The rest of the 4 were also found to be.
No, Lordship, it was not found.
See the
Lordship-
verification report.
Lordship, speaking order was passed. And Lordship, I have stated in my written synopsis that order was passed. That was never challenged before this honorable court. They came directly and their claim for other 4 petitions was rejected by the Home Ministry, Lordship. And speaking order was passed. That was never challenged before the court in any of the proceeding, Lordship.
Where is the speaking order?
Lordship, it was annexed in affidavit filed by, we have,
Not part of the records here.
it is part of the record. Ajay Kanojia's affidavit, Lordship, for this order annexed.
Affidavit by?
Ajay
Dated?
Kanojia. At the relevant time, he was the director of Northeast in Home Ministry, Lordship.
Acha. So what is the date of the affidavit?
Lordship, I am giving, Lordship. I'm sorry, Lordship, it was in contempt number 7, Lordship, not in this case, Lordship. Not in this case. In earlier case, speaking order was passed. That is on
You have mentioned it in the written synopsis?
written synopsis.
Okay. Speaking order?
In contempt
This
number
is in relation to item 1, Your Lordship.
7 of 2016, Lordship.
But
It
no,
was
as
speaking
far
order
as
dated 3rd of June 2016.
his case is little different, Mr. K.R.
Yes,
He
Lordship, it
says-
is a quite
Huh.
different, Lordship.
Then why only 5 and not the others?
Lordship, because their land were not found to be occupied by the security forces.
You
at the
have not
relevant time.
challenged that verification
Lordship,
report?
whether it is required. In my emulsion, it is not required. Because Lordship
Then
direction.
what is the purpose of court's order?
No, court's order is, Lordship, clear. It was clear that Lordship, see, the minutes of the meeting, it was never considered by the Ministry of Home Affairs and time and again it was, Lordship, signing will not do. Our objection is there. That was written by the Home Ministry to the State of Mizoram, Lordship, in 2013 itself.
No, but then there is an order, do a spot verification and find out the proper persons. They have done, they have found 5 persons. Now you leave to 4
No,
persons.
Lordship, please to see the minutes, whether it was consented by the representative of all the stakeholders, Lordship.
In the spot verification?
Yes, Lordship. It was, objection was raised time and again,
Where is the objection in that spot verification?
Lordship. Lordship, Annexure 2 of my affidavit dated 24/7/2024.
That Bhalla?
Yes, Lordship, Bhala's affidavit. Annexure 2 is a letter dated 26 June 2013.
So what I can feel is that the land, nobody is sure as to which land has been occupied by the forces.
Yes,
What
Lordship.
is in the blueprint area?
Correct, Lordship.
Nothing. It was just lying
This was
and they
the,
were occupying.
that's why this court has time and again directed the State of Mizoram and as well as the Ministry of Home Affairs to verify the land and find out whether the land is occupied or not. That why
And
Lordship,
there are differences of opinions.
This was, access was taken and loop map was prepared initially in 91-92, then subsequently 2009.
And rental compensation was not paid for 66 to 86, not paid, right?
Not paid.
It was,
Entire period.
Yes,
in
Lordship.
this case, they said that they are not paid. And the contention of the Home Ministry
The
and.
certificate was also issued by the DC where non-payment of rent.
From 66 till date, nothing is paid.
Yes, it is contention of the petitioner, Lordship. And Lordship.
Contention of the
Lordship
government.
had, taken record that Ministry of Home Affairs till date paid about 200 crores to different petitioners whose lands were
Those
found.
are not before us.
No,
Those are
Lordship,
different.
I'm just making a statement, Lordship, for consideration of your Lordship.
Acha,
it is not
annexure
that-
2, what you wanted to show?
Lordship, page, a letter dated 26 June 2013. It was written by the Home Ministry to the Secretary, Revenue, Mizoram, State of Mizoram, in 2013 itself, that in response to your letter dated so-and-so, on the above cited subject, it appears that the WPC number 8 of 2010, out of 25 persons, rental compensation has to be so far been released in respect of Mr. So-and-so. rupees
Miss so-and-so.
One
This is
petition.
number 5.
Yes, Lord. That respondent
somebody
submitted the
else.
17 in respondent number, petitioner number 17 writ petition and 5 in contempt petition. But the-
Matlab 5 in the verification list.
Yes, Lord. With period from
Amounting to so and so.
1696 to so-and-so pursuant to Guwahati High Court's Aizel's bench judgment and order dated so-and-so, while in 5 cases of rental compensation has been assessed and claim forwarded by the state government, it is not clear as to what is the position of the remaining petitioners, whether their claims have been examined and not been found genuine, or the same is yet to be re-examined, considered by the joint verification team.
So this is after the verification.
Yes, Lordship. It is later dated 26 June 2013.
Verification done when?
It was done, my note was prepared on 2nd of May 2013. So these things were put on record by the Ministry of Home Affairs before the Revenue Department of the State of Mizoram, Lordship, in 2013 itself. So the contents of my learned friend that we are sitting about the matter for last 10 years, 15 years, it is not correct, Lordship. Yes, affidavit was filed in 2014. In the meantime, different persons have been retired and new incumbent and joined, and they have been implemented as respondent.
You could have challenged.
Lordship, in my humble submission, it is not required to be challenged because objection was raised at the relevant time and direction of the court was to verify. And we are not agreed with the recommendation. Lordship, we have right to raise before them same authority, Lordship.
No, if you are not satisfied with a verification, there are ways for you to,
No, that was not challenged, Lordship. It is on the record, Lordship.
because otherwise you will be in contempt proceeding, right?
No, Lordship,
If you
that-
don't follow it, then okay, you did not agree to the spot verification. You should have challenged it.
Now, Lordship, this is the factual position of before I place before Lordship. If
Without
Lordship,
challenging,
Lordship,
now you come and say that no, they are not entitled.
Lordship, because we have followed the direction of the Honorable Court in letter and spirit, and we have not violated the court's order in any point of time, Lordship. This is my submission, Lordship. If Lordship finds that something has been committed deliberately, then Lordship pass an order. And Lordship, another thing, the case is fixed for admission, and the new incumbent has been recently added as a respondent, and the other officer of the.
After such a long hearing, you are saying this.
No, Lordship. I'm just pointing out before Lordship. And in the meantime, Lordship, Director General of Assam Police, so he has been retired and some other person is joined. Just for convenience of your Lordship, I am just appraising your Lordship. This is not my contention that, and we file affidavit by Ajay Bhala. He has also been retired. He has been, now he is placed as the Governor of Mizoram, Lordship.
You should have told it beforehand.
Lordship,
Please, Your Lordship, that will
he
not
has
come in the
been,
way.
new incumbent has been implemented.
Yes, he should have started with that.
No, Lordship, I am not raising
New
any
incumbent
objection,
has
Lordship.
already been impleted.
I am not
He is
objecting any
representing the
objection,
new
Lord.
incumbent.
My contention is that there is no deliberate on willful violation of the honorable courts. Lordship has to decide. I have submitted my written submission also.
No, every time new people will come, somebody will retire, but
No, Lordship,
that
this is
cannot-
not my condition. Lordship may issue, if Lordship thinks fit that they have committed contempt, Lordship may issue contempt. There is no, I cannot submit on that, Lordship. But my submission is that there is no deliberation or willful violation of any of the court's order, Lordship. This is my humble submission.
because of the steps that you had taken.
Yes, Lordship.
Okay.
Just to rebut,
Yes.
it won't take long, Your Lordship. What my learned friend has pointed out, all those communications 2013 onwards, these are internal communications between the union and the state. Question number one is, will it come in the way of the judgment of this honorable court? It cannot. The direction has to be assailed. And as far as the new incumbent is concerned, Your Lordship, Mr. Govind Mohan, the present Home Secretary, was implemented as respondent number 15 via order dated 4/3/2025, and my learned friend has also submitted a Wakalat Nama in respect of respondent number 15. And as far as the DGBR of Assam Rifle is concerned, we are not really concerned with that because they won't be the paying authority. The reason being is that the period from 66 to 86, that is insurgency period, that was considered as internal matter, as an internal security issue. So that's why the entire apparatus was under the Ministry of Home Affairs. So we're basically concerned with only Home Affairs. And then even if we implement the DGBR, it ultimately boils down to the Home Secretary home again.
It's okay. Let it be disposed of. And you please give me one written
I shall do that
synopsis
by Friday.
Before Friday.
Yes, by Friday also.
Okay.
Lordship, they may be directed to supply copy of that.
Uh-huh.
It's
You give
written
him a
argument,
copy.
I don't need to supply.
Yes. Okay, arguments heard and hearing concluded, judgment is reserved.
Lots. Much of it.
Just clarify on that blueprint area and the
I shall do that,
bo-
yeah.
security forces. Of course,
I
you have shown that order where it says it's a different thing. Send me to my chamber, huh? I don't know. Thank you.
Item 3.
Yes.
My Lord, in the last court date, this Honorable Court was surprised of the review petition pending in the Supreme Court.
Oh, acha.
Now, we have an order of the Honorable Supreme Court wherein the review of the special leave petition was dismissed
Acha.
by the Honorable Supreme Court.
Okay.
Now, the counsel for the respondents are absent today. I don't know why they are absent.
Lordship, Mr. Pyongju Goswami has requested me to appear on his behalf today. That, my Lord, he said that he did not know what happened thereafter the review petition was filed, and that he have to take instructions regarding the steps and development which were made in the Supreme Court. And he asked me to request it for 2 weeks' time to take instruction, my Lord.
Acha, let me go through the order, wait.
Yes.
My Lord, may I place the review order?
What about the condonation? Condonation is, there
It
was
was-
condonation, there was delay.
It was dismissed, the condonation for filing review against SLP. Now SLP, that review against SLP was also dismissed.
No, if it is, if the delay is not condoned, there is no question of dismissing the SLP.
If your Lordship will see the order which I have just placed. No, delay was condoned.
Oh, acha.
Delay was condoned, sorry. Delay was condoned and
Was dismissed by this special leave petition. 5720 was for delay. Oh, what?
5720 is the SLP.
Acha.
Your Lordship will see page 3.
There is a, yes. Delay condoned, application for hearing, review, acha. So the review is rejected.
Review is rejected. They have exhausted all their remedies. I don't know what option now they are trying to take.
This is a, what, contempt?
Contempt. Today, my Lord, my prayer is very simple today. Let the respondent be called before this court and let them explain what has transpired and what they are going to do.
He wants some time, Mr. Goswami has some difficulty.
This,
I'll just go through the order one. Okay. So what is your prayer today? Review is otherwise gone. All
Yes,
your
my lord.
legal records are gone now. You have to comply with the order.
Yes, my Lord. So it's just 2 weeks' time to take instructions from the company, my Lord.
Okay, heard Mr. C. Lal Fakjuala,
Zola.
learned counsel appearing for the petitioner, and Mr.
Lomo Maralte.
For respondent number 1 to 6.
Yes, my lord.
Yes,
On behalf
ma'am.
of Mr. Priyangshu.
Uh-huh.
On behalf of Mr. Priyangshu.
On
Goswami.
behalf of Mr. Priyangshu Goswami. Mr. Lal Fakjuala, learned counsel for the petitioner, submits that the review filed by the by respondent
NPCC. 3 to 6.
he is respondent number so and so, that is National Zonal Manager, National Projects Construction Corporation Limited, NPCC Limited. What, how did I start? Submits that so and so. Respondent number so and so has been dismissed by the Honorable Apex Court, and he has placed the order dated 19th of August 2025. However, Mr. So-and-so for the petition, for the respondent number 1 to 6, appearing for Priyangshu Goswami, submits that the conducting counsel needs some time to get some clarifications in the said matter, some instructions in the said matter, and has prayed for some time. Prayer is allowed. List this matter on when?
My lord, let my prayer be reflected. My prayer is that let the personal attendance of the respondent be called. As per the order of this
Oh,
court.
personal attendance you want?
Yes.
Acha.
After
Personal
2 weeks.
attendance of respondent number 1 to 6.
Respondents 3 to 6. 1 to 6. I'm sorry.
Acha, Mr. Lal Fakjuala submits that in view of the rejection of the review as well as the time taken by the respondents in the instant petition, and in view of the non-compliance of the order, has prayed for personal appearance of the contemners
1 to 6.
1 to 6 in the present petition.
With respect to respondent, newly impeaded respondent number 7, I have to take a fresh step, my lord.
Acha. Full stop. As far as respondent number 7 is concerned, it is seen that the notices have been issued to
It has been issued, but the consignment note says that article has not been booked. So
Achha.
it might have been lost in the transit.
postal receipt from so and so laid before. Oh no. What? This is cut it. As far as notice upon respondent number 7 is concerned, the office note dated 8/9/2025 reflects that the consignment, the postal consignment was tracked, but the same showed that articles not booked, and as such, the learned counsel for the petitioner prays that he may be allowed to take fresh steps
Yes, fresh step. my lord.
steps upon respondent number 7. Prayer is allowed. List this matter after 2 weeks.
Yes, my lord.
After vacation or what? No,
After
but then
2
it's
weeks.
taking long week. No,
It's ve-
7 years have gone.
Yes, and it's from the date of passing of the word, it's 10 years already.
After 2 weeks on a date to be fixed by the registrar.
God
Much
bless, my lord.
obliged.
Item 4.
The order passed by the Honorable Supreme Court in review petition is kept as a part of records. Item number? Yes, Mr.
Your Lordship,
Malhotra?
in this, the paper book has been prepared and we have received it. It can be listed for hearing.
Okay. Miss Linda, you are there?
Yes, my lord, I'm for respondent 1 to 4.
So otherwise, service complete, pleadings complete,
Hearings
everything?
can- Yes, it can be listed for hearing in the usual
Okay.
course.
Heard Mr. A.R. Malhotra for the petitioners and Miss Linda Fombal for respondent number
1 to 4.
1 to 4. And there are others also, but then,
Yes.
okay. It is noticed that a paper book has been prepared in the instant case. And the service is also complete with respect to all the respondents. And as such, this court deems it fit to fix the matter for hearing after the vacation
Yeah, in the
or
usual
on a
course.
date.
No, in the usual course, yeah.
Acha.
Because
In
they,
its usual,
yeah.
in its usual course.
Item 5.
I think Miss Aziu is on bereavement, right? Aziu appears.
My lord, for respondent number 1, I'm seeking 3 weeks' time for filing affidavit.
Okay.
I'm appearing for the petitioners, my lord.
You are appearing for?
Petitioners.
Yes, wait. Earlier also you had taken time, Ms. Zairang Sampui.
Yes, my lord, however, the state also not yet filed. Then Kala also not yet filed. my lord.
Lordship, I am appearing for respondent number 6.
Acha, okay. Heard Mr. Victor. What is the surname?
Ralte.
Ralte, yes. Victor Ralte for the petitioners. And Ms. Zairang Sampui for respondent number 1.
Yes, my lord.
Respondent number 1 and yes,
Respondent number 2, we've already filed, my lord.
you have filed your affidavit also?
Yes, my lord.
Okay. So,
On behalf of NHIDCL, my lord.
okay. Respondent number so and so, and you are for
Respondent number 6.
6. What about 3, 4, 5?
3, 4, 5 is state, my lord.
So who is appearing? Yes, Veneshyami. Miss Veneshyami appears for respondent number 2, 3, 4. No, 3, 4, 5.
3, 4, 5, yeah.
3, 4,
lordship.
5. Mr. Samuel for 2.
2, my lord.
Mr. Samuel for 2 and Mr. For 6. 6, right? Miss Veneshyami. Oh, no, not Veneshyami. Miss Zairang Sangpui appraised that she may be allowed some more time to file her counter affidavit. Prayer is allowed. List this matter after. 2 has filed affidavit.
Yes,
What
ma'am.
about state?
Only 1.
Only 2 has filed, my lord.
Oh,
Rest have
okay.
not
You
yet
will file affidavit? State will file?
Your lordship, I'm not very sure because this case is handled by Miss Lalnun Louis, so
Acha.
I'm not sure whether the affidavit has been filed or not. So in any way, I'm seeking 2 weeks' time.
Okay. Ms. Veneshyami prays that that time may be allowed to file an affidavit. Full stop. You will also file?
Yes, my lord.
Respondent so and so also seeks some time to file affidavit. Respondent number 6. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
Item 6.
Yes, Mr. Victor?
In this case, my lord, there is a subsequent development after filing the writ petition. So I'm seeking withdrawal of this case with liberty to file afresh. Instead of filing amendment, I'm
You
praying
have
for.
already filed your affidavit. No, no, what? Subsequent events?
There is subsequent development in the case, so I'm seeking for withdrawal of this writ petition with liberty to file afresh.
Oh, you want to withdraw this?
Yes, my lord.
Or you can file one additional affidavit.
It will be better, my lord, if I
Acha.
withdraw,
Of course, if
And
you
file
have
afresh.
some other prayers, right.
because the
Prayers
entire,
cannot be made by way of a subsequent affidavit. Okay. Heard Mr.
with liberty, my lord.
Okay. Liberty is always there. Heard Mr. Victor L. Ralte for the petitioners and Ms. Zairang Sangpui for
Respondent number 1 to 3.
1, 2, 3. Ms. Veneshyami for
4 and 5.
4 and 5. And you?
Darin Thari for 6 and 7.
6 and 7. Mr. Victor Ralte submits that some subsequent developments had taken place in the instant case, and as such, he prays that he may be allowed to withdraw the instant petition with the liberty to file a fresh one. Prayer is allowed. Matter is disposed of as withdrawal. As withdrawn.
With liberty.
With liberty. With liberty.
Item 7.
Revision by state or what?
Lordship, yes, Union of India,
Oh,
filed by the
Union
Union
of
of India.
India.
Lordship, yes.
My lord, in this case, I've recently been appointed to represent the respondent, both the respondents. So, my lord, I seek 2 weeks' time to have further time for preparation.
What is this matter about?
Lordship, this is regarding methamphetamine.
Huh?
Methamphetamine.
Seizure of methamphetamine.
This has
So-
come up for the first time.
No, Your Lordship.
After the condonation of delay, this is the first time.
Oh, there was a delay.
Yes.
Lordship, yes.
Oh, against discharge.
Again, discharge, Your Lordship. This is
Okay, right. Heard Mr. Johnny.
Johnny, Lordship, yes.
Heard Mr. Johnny L. Tachwang for the Union of India and Mr. I forgot.
Lalrokung Apatu.
Uh-huh.
Lalrokung Apatu.
Lalrokung Pautu for the respondent, sole respondent,
Two
Both
respondents.
the
Lordship,
respondents.
one and
for the respondents. This is an application by which the order dated 29/8/2024, passed by the learned special judge NDPS, Aizawl District, Aizawl, in sessions case number 132 of 24, discharging by which the accused persons, that is the respondents, are discharged from the allegations, charges under section 21 and 29 of the NDPS Act 1985. Mr. Pautu, appearing for the respondent, submits that he has been recently engaged and that he needs some time to go through the record, so you'll file some affidavit. Not required.
Not required, madam. I'll
Go through the instant petition. Prayer is allowed. List this matter after 2 weeks.
Madam.
Or you want a date?
After 2 weeks, madam.
After 2 weeks on a date to be fixed by the registry.
Lordship,
I'm obliged. Item 8.
My Lord, I am for respondent number 1. I am seeking 3 weeks' time for filing my affidavit.
My lord, as per the last order, mediation was requested. And in fact, my lord, the respondents should have, my lord, come up with instructions as to whether the a possibility of mediation can be
On the
taken.
last occasion only,
Yes,
the
madam.
mediation was considered to be a recourse. It is submitted that similar matter has been resolved through mediation and prayer is accordingly made on behalf of petitioners to refer. Present praise for abstain. So instructions are there, Ms. Zairang Sampui?
Not yet, my Lord.
Not yet. Okay, right. Heard Mr. L. Pautu, learned counsel for the petitioner. Ms. Zairang Sampui for the state respondent number 1.
Respondent number 1.
1, 2? Only 1.
Only 1.
Union is 1,
Mr. Samuel
for 2 to 4.
from, for respondent number 2 to 4 and Venetiami for respondent number 6.
5 and 6, my lord.
5 and 6. By the last order, it is reflected that since mediation had resolved similar matters, the prayer is made that the instant matter may also be referred to mediation. Full stop. It was further observed that the learned counsel should get instructions on that regard. However, when the matter is called up today, Ms. Zarang Sankui submits that she is yet to get the instruction. But you are agreeable for mediation?
My lord, sorry.
Did you get the instruction whether parties are agreeable for mediation?
Yes, yes, they
Acha.
will comply with the mediation.
Acha, Mr. Pautu submits that the petitioners are agreeable for sending the case to mediation. Mr. Pautu, Mr. Samuel, mediation?
We have no objection, Madam.
Acha. And Venetiami also? Only one has to get instruction.
The union.
Union. Union, no, union.
Respondent number 1.
Respondent number 1.
Ministry of Road Transport and Highway.
Union of India should always agree for mediation. Right. So let us send it for mediation.
My lord, I already sent all the lists to the concerned department, but I didn't receive the instruction.
Acha, Miss Miss Zairang Sangpui submits that she had although sent the required communication to the concerned authority, but she is yet to get the instruction on the above mentioned subject and has prayed for some time. Prayer is allowed. List this matter after a week. You get the instruction
Yes, my lord.
telephonically. List this matter after a week on a date to be fixed by the registry.
I'm obliged.
Obliged.
Item 9.
Yes, Mr. Malhotra.
Affidavits are still awaited.
Lordship, yes?
Judge, the affidavits are still awaited.
My lord, I have not received the Parawise comments yet. If 3 weeks' time can be granted, my lord.
Acha. Some provincialization. I was there on the last occasion.
Yes, Judge. This is regarding pay matter, Judge. ROP, revision of pay was
Oh, yes, I
implemented
remember.
from a subsequent date. Although it was given from 1106, then it was given from 1/4/2008.
Okay, heard Mr. A.R. Malhotra, learned counsel for the petitioner, and Ms. Linda L. Fumble, learned additional advocate general, appearing for the state of Mizoram. Ms. Linda submits that she is yet to receive the Parawise instruction from the concerned authority and has prayed for some time. Prayer is allowed. List this matter after a week.
3 weeks, my lord.
After 3 weeks, then it will go after vacation.
Yes.
List the matter after the vacation on a date to be fixed by the registry.
I'm okay.
For orders, item 10.
Lordship, in this matter, in this RFA, there was a delay of 553 days.
This is state's appeal.
State appeal, Lordship. I have filed my
You come
objection,
decide.
Lordship.
Oh, acha, you are the appellant. Okay.
Lordship, I have already filed my objection. However, Lordship, this may be taken up on some other day. Today I'm not ready for the hearing.
Why has it come up for orders today?
The matter is for continuation of delay, Your Lordship. Hearing on
Continuation of
continuation.
delay.
Yes, Lordship.
How many days delay?
353 days.
You have filed an objection
Yes,
also.
Lordship, I have already
But
filed.
then you don't want to do it today.
Lordship, some other day.
Okay. Heard Ms. Veni Shami for the appellants and Mr. Johnny.
Johnny, Lordship,
Yes,
yes.
Johnny L. Tachwang for respondent number 1 to 4. This is an application for condoning the delay of how many days? Delay of
353 days.
353 days in preferring the connected RFA. Although the objection to the said delay application has been filed by the learned counsel, but Mr. Johnny L. Tachwang prays that he may be permitted to, he may be allowed some time in conducting the matter.
Lordship, yes.
Prayer is allowed. List this matter after a week.
After a week. Any time after a week, Lordship.
Anytime after a week.
Lordship, yes.
On a date to be fixed by the registry.
Item 11.
So it returned unsettled. It was not settled in the mediation.
Yes, my Lord.
Okay, it will proceed then. So today what to be done? That was the last order. Okay, right. Heard Mr. Lalan Pui.
That's my senior. My name is Kelal Himpuya.
K. Lalpuya. Mr. K. Lalpuya for the applicant.
Appellant.
Huh?
For the appellant.
For the appellants. And Ms. Veni Shami for respondent number 2 to 5.
2 to 5.
One
Your
is
Lordship.
who?
My Lord, the respondent number 1 is...
Private respondent.
Notices have gone.
Yes, notice has served and a complaint affidavit is also submitted here in this honorable court, and unfortunately the respondent number 1 has since expired.
Oh.
So intimation has given to his daughter, Mrs. Lam Hing Kui, but she saw no interest in participating in the present case, and she also refused to accept the notice of 26/2025.
What is the matter about?
It's the matter about custodial debt, Your Lordship.
What?
Custodial debt.
Oh, custodial debt. Custodial debt of one person. But then, in that case, respondent number 1 may not be there.
Yeah, Your Lordship, the respondent number 1, with regard to respondent
How is
number,
respondent number 1 involved in this custodial debt?
he was the stepfather of the appellant son, the one who demised on 11/4/2024 at Bongkon Police Station.
Stepfather.
Yeah.
And the one that you have served notice is the stepsister, who
Yes,
has
my lord.
refused.
Yes, my lord.
Okay, right. Heard Mr. Swenson? Yes, ma'am, Miss Venishani. By the last order, dated 30/7/2025, the instant matter was sent for mediation. However, the office note dated 4/9/25 reflects that the same returned unsettled vide mediation case number 10/2025. But how can the custodial debt be sent for mediation? Right?
Exactly, Your Lordship. I didn't receive the RFA copy at the moment, so I cannot
Certain
say.
cases cannot be mediated. Custodial debt, that has to be seen. Okay, by mediation case number 10/2025, ordered by 10/2025, wide order dated, one order or what? What wide order, settlement order only, order dated 4/9/2025. Since the mediation has not come out successful, the matter to be listed again in its usual course, right?
Much obliged.
Item 12.
Lordships,
Yes.
Lordships, I beg to appear
You were here
through
in the
VC.
court. You were here.
Yes, my lord, some personal emergency had occurred, my lords, I had to rush back.
Yes, it's okay. Today, what has to be done?
My lords, I'm appearing as amicus in the matter. Respondent number 2 informant has received notice. And your lordships, in the last occasion, the order says that, my lords, if the private counsel does not come, legal aid counsel may be appointed.
Okay, it's a POXO matter.
Yes, my lord.
Yes,
So let me appoint a legal aid counsel to defend her. Okay, heard Mr. J. Roming Tonga, learned amicus curiae for the appellant, and Miss Linda Fomble for the state. It is seen that that although the notice is served, right?
Yes, my lord. It's
Although the
complete.
notice is served upon respondent number 2, but no one has appeared on her behalf, and as such, this court deems it fit that a learned legal aid counsel may be appointed to defend respondent number 2. Accordingly, Mr. Pautu was here. Mr. L. Pautu, yes, you can appear as as a legal. L. Pautu, Lolro Kunga Pautu is appointed as the legal aid counsel to defend respondent number 2. The registry is directed to serve him a copy of the paper book to the learned legal aid counsel. The matter to be listed, not a very old matter, 25, right? The matter to be listed for hearing in its usual course. Okay? In its usual course? Yes.
Items 13 and 14.
Paper
Lord,
book
this-
served.
I have
It-
received the paper book
Yes, AD card has also been returned.
duly represented respondents.
All respondents are represented?
Yes, my Lord.
Yes, I'm represented the sole respondent.
All the respondents?
Yes, ma'am.
And my Lord, this item 13 and 14, they were arising out of one common judgment and order. And one is in respect of landed property and the other in respect of bank account. So I'm filing these two RFA challenging the same common judgment order. And the appeal has already been admitted, my Lord, and paper book we have received. It
So
can be
let
listed
it come
for
up for
hearing.
hearing then
Yes,
in
my
the
Lord.
usual course?
Yes, my Lord. In the meantime, my Lord, there was an interim order passed by this court. Stay was there. This stay may be made absolute.
Okay, heard Mr. Victor L. Ralte for the petitioners and Ms. Jacinta Jat
Jautan Moyi.
Maui for the respondents. It is noticed that a paper book in the instant matter has been prepared and the respondents are also represented. In view of the fact, let this matter be listed for hearing in its usual course. The interim order passed earlier shall continue till then. When it is listed? It will be then till it is taken up for hearing.
One more point, my Lord. Just for the sake of clarity, my Lord. Since these two RFA number 17 and RFA number 6 were clubbed together, and in RFA number 6 of 25, my Lord, there is IA still pending.
Or that interim?
Yes, my Lord.
No, and there is no interim and item in 6.
In item number 13, my Lord, in item number 13, that IA has already been disposed of. But in the main appeal, interim order was made.
So I is pending in both the matters?
No, my Lord, only in item number 14.
Oh, that there, what is that I for?
Stay.
Acha. So interim granted.
Yes, my Lord.
So
The IA can be
is
disposed of, what I mean to
disposed
say.
in 17, but I is not considered in 6.
Yes, my Lord.
But the same matter, arising
Same
out
matter,
of the same.
arising out of same common judgment and order.
So that will be applicable in the other one also, the interim order.
So, yes, my Lord, my humble prayer is that let the, in either one of the case, my Lord, let a proper order be passed to make the interim order absolute till disposal.
Give me the second matter.
RFA number 6, the IA number is 36.
Acha, last time respondent took time to file an objection to the IA.
Yes, my Lord, but I have no objection because the judgment and order is, both the cases are in similar judgment and order. Because of that, no.
So you will not file any objection here?
No.
You have
no, my
already
Lord.
filed it there, and it was considered, or what?
In the last court, I paid to file a objection, but I have no objection when I have gone to the IA.
Acha, where is that IA for, IA number 36?
Yes, my Lord.
In the second matter?
Yes, my Lord, IA number 36. And having the appeal already been admitted and listed for hearing, to be listed for hearing, it will be just and proper to stay the impugned judgment order.
27-2 was the impugned judgment there also?
Yes, my Lord. It's a common judgment order, my Lord.
So that's a common judgment, so let interim be here also. Right. Heard Mr. In the other matter you write? In other matter? In item number 14, heard Mr. Victor L. Ralte for the petitioner and Ms. Jacinta for respondents 1 and 2 only, right?
Yes, my Lord.
1 and 2. 1 and 2. The in this application, the petitioner has prayed for stay of the judgment and order dated 27th of February 2025, passed in airship case, right?
Yes, my lord.
Airship case number 83 of 2018. It is noticed.
And, my lord, and succession.
This is only airship, oh yes, and succession case number 2103 of 2018. It is noticed that against the said judgment and order, one RFA, another RFA, being RFA number 17 of 2025, was filed and a stay of the said judgment was granted by the order dated
In that case also, my lord, only interim is there so far.
and a stay was granted by the order dated 15/5/2025 to the effect that the impugned judgment and order shall remain stayed till the next returnable date. And the same is continued till date in the other RFA, that is RFA number 17 of 2025. Since the present application is in connection with RFA number 6 of 2025, in which the same judgment and order was put to challenge by different parties.
Same parties.
Same parties.
Then why two RFAs?
In two cases were clubbed together by the landed trial court. One heirship and one succession.
So?
In respect of landed properties, and one is bank account.
So this is in respect of 17, RFA is,
Landed properties.
and this is bank account.
Yes, my lord.
This is matlab in succession.
Yes, my lord.
So what did I say? Or you file an objection if you want. This is totally a different aspect. This is in respect of bank account.
That the stay order is in respect of the bank account, and it is a common judgment, and it is automatically, as per my understanding, it is automatically affected to the landed property, no? Because it is under the sub judice, and we have no chance to take any
Okay, then you write. What did I
Action.
say? Was put to challenge. The interim stay may also be effective in the instant case, and as such, the same is allowed, and the same may be extended till the date of hearing. List this matter for hearing on
Usual course, my lord.
in its usual course.
Much obliged.
Deeply obliged.
IA is disposed of. IA is disposed of. That IA is, no, not disposed of,
It can be disposed of, my lord.
but an interim stay only.
Otherwise, it can be made absolute till disposal of the appeal, connected appeal.
What do you say, Ms. Jacinta?
It's one and the same only, my lord.
Stay may be extended till, okay, it is disposed of. Oh, that is disposed of, right? Okay, and disposed of.
Deeply obliged.
Much obliged.
Item 15.
Item
Your Lordship, paper book has not been prepared yet. We have not received it.
Yes, paper book ready. Ready. What about service?
Paper book has not been received by
Oh,
the...
paper book is always ready.
We have not received.
Not furnished.
Not furnished.
To you also, Miss Venishami? You also, not
Yes,
furnished?
Your Lordship.
No, supplied to learned counsels for both parties. Otherwise, note reflects supplied to both parties.
You have to check it.
Whether you have signed it or not.
Your Lordship, we'll check it in the meantime if the matter may be adjourned for. And also the matter is being taken up by Miss Mary, I think.
Miss Mary will do it.
Yes, Your
But
Lordship.
otherwise it is said, it's reflected, right? Signatures are there. As far as PW, respondent number 2. Silo only, huh? I don't know about AD card. They put signatures after receiving the paper book. Signature. Okay. Matlab the present councils will also, there will be an AD card with respect to present councils also? Oh. And whether it is under POXO or what? 307, 326? So not required. Okay, heard Mr. Jonathan L. Silo for the amicus, the learned amicus curiae for the petition, for the appellant, and Ms. Venishami for the respondent. Mr. Jonathan Silo as well as Ms. Venishami has submitted that they have not received the paper books.
My Lord, I can check whether it's been received by my office or not.
But although it's written supplied, but then there is no signature on the ID card. So, no, you're right. Mr. Jonathan as well as Venishami submits that they may check whether the office has, they may check as to whether the paper books has been received. Although in the office note, it is reflected that paper books has been supplied to the learned counsels for both the parties. Prayer is allowed. List this matter on after 2 weeks to on the date to be fixed by the registrar.
Item 16.
Yes, Mr. Johnny.
Lordship,
Why
this
it
is,
is for orders?
Lordship, there is a continuation of delay in filing the criminal appeal. And this is appeal filed by the Union of India. So I have filed SLP, and by filing the SLP, there was a delay. So IA, this...
Let the delay condonation application be taken up first.
Yes, Lordship, yes.
I'll issue notice to the respondents today.
Yes, Lordship.
You right. Heard Mr. Johnny L. Tachuang for the appellant. This is an interlocutory application is for condoning the delay of 406 days
Lordship, yes.
in filing a special leave application is not required. In filing the criminal appeal, SLP will be considered after condoning.
Lordship.
Once first condonation, then leave, then the main appeal.
All right.
So this is this, what is this? NDPS? What
Lordship,
is
this is a
matter?
gold case. Gold
Huh?
case. Gold.
Customs?
Yes, Lordship.
Okay. So and so, in filing the connected criminal appeal
22 of 2011.
for challenging the judgment and order dated 25/1/2024 passed by the Chief Judicial Magistrate Shamphai in criminal complaint, COMP complaint.
Lordship, yes.
Complaint number 22 of 2021. issue notice to the sole respondent, the petitioner to take steps for service of notice upon the respondent by registered post with AD or with usual process within a period of 3 days from today. List this matter after 2 weeks.
Item 17.
May I please, Your Lordship?
Yes.
This is
Here
a appeal
also
against
some
order passed by
delay.
reference court.
Here also some delay.
Yes, my lord, 170 days delay.
Okay, let me issue notice to, today.
All right, my lord.
Heard Mr.
Last Soirema,
Lalsam Virema.
my lord.
Lalsam Virema for the appellants. And Miss Venisham, you are appearing?
Yes, Your Lordship.
You are appearing for?
1 to 5, respondent number 1 to 5.
This is item 17, right? 17. Venishami for respondent number 1 to 5. So all the respondents were
All the
appearing.
respondents.
So no notice, right? This is an application for condoning the delay of how many days?
120 days.
117 days, 70 days
7.
in filing the connected appeal. Connected LA appeal, land acquisition appeal.
My lord, land acquisition appeal, my lord.
Land acquisition appeal. Ms. Venishami appears for all the respondents, and as such, no formal notice is required to be served upon her. However, extra copies may be given to her by the learned counsel for appearing for, by the petitioners, by the appellants. List this matter after 2 weeks on a date to be fixed by the registry.
I am
Give
obliged, my
extra
lord.
copies. Okay.
My lord.
And Venishami, you will file affidavit?
Yes, Your Lordship. I will file.
Ms. Venishami also prays that she may be allowed to file her affidavit in the instant case. Prayer is allowed. List this matter after 2 weeks.
Item
My
18.
lord, similar order can be passed in 17 and 18 also.
Acha. 18 also you write same. Okay.
18 and 19.
19 also same.
Yes, my lord.
17, 18, 19 is similar case.
Okay. So 19 also same.
Yes, my lord.
Yes.
Hearing list, item 1.
Yes, Mr. Malhotra, I remember seeing this case yesterday. Because of my health condition, I couldn't see anything. But what is this?
It's up to your lordship. We can take it up on Thursday also, if your lordship is not
The
feeling well.
case diaries are case diaries, right?
Case diary.
Both
Lordship-
the cases are there, SIT and well did this one. Mr. Samuel?
Your Lordship, the SIT diary has been furnished to me.
And
Only
the
the
other?
SIT.
Only SIT.
Yes, madam.
But I think both the case diaries were called.
You had instructed the
State Police, that one, that case diary is not there. Not there. Then you have to bring it.
Yes,
When
my
can
lord.
you bring it then? Otherwise, matter is pending since long, 2019, Mr. Samuel.
Yes, my lord.
When can you bring it?
Your Lordship,
That will be from your, what happened? That will from your state
is-
police.
Sampaikan dalam CJN.
Case diary, not Manikol, the case diary.
Charge sheet is not there, right?
There's no charge sheet. Final report was there.
Acha, final report here.
Yes.
Then objection and all.
Yes.
Narazi. Then
Yes.
again what happened?
Further investigation was directed.
Further investigation was done. Then report?
Then your SIT was constituted.
Hmm.
They submitted a report. We filed a protest petition. Again, the Honorable CGM Champai directed for further investigation. So now till date, the report has not been submitted.
Oh, after further investigation, no report.
Yes.
Further investigation by SIT.
Yes.
I can ask for the case diary, my lord.
Of
if
the
you'll-
state police, you bring it, the initial investigation
Yes.
Yes, my lord.
By
part.
Your Lordship, in that matter, if I may, the initial, if Your Lordship will kindly see page 16 of the petition.
Yes.
The final report, this is the final report.
No, what I'm holding. This is what, GD entries, what?
Yeah.
Page 16 is an entry.
Yeah, this is the final report submitted before the CJM.
I therefore return the case in final report.
Yes.
As the case is true, but mistake of fact and the case may be revived if the case is detected in future. Okay. After that, okay, Narazi and all that, then no report on the further investigation.
Yes.
So, Mr. Samuel, you produce, you have the, what, you have
I
the...
have the SIT.
SIT has not finished their investigation
No, my lord.
on the direction of the CJM?
As per the communication received, my lord, the report has been completed and given to the CJM, I believe, my lord.
On the further investigation?
Yes, my lord.
Then you
However,
bring
I
that-
can bring the diary.
That you can bring, that you have to
Yes.
bring it,
Yes, my lord.
what they have found
Because
out.
Your Lordship will see the page 49, page 48, the CGM had ordered a further investigation. That was in 2019. We're in 25. Investigation is still carrying on. But I understand due to COVID, there was some problem. But we are now, after COVID also, a couple of years have passed. So whether they have finalized the,
But then he said that here they have submitted a report.
I mean, no.
Okay, right, heard Mr. A.R. Malhotra for the petitioners and Mr. Samuel. You are for respondent number?
1 to 4.
1 to
Sorry. Yeah, Mr. Samuel is for respondent number 1 to 5.
1 to 5. my
1
lord.
to 5. And then,
And for respondent number 6, 7, 9, 10, and 11.
and Ms. Zairang Sangpui is for respondent number 6, 7, 9, 10 and 11. What about 8?
Even 12, 13 and 14.
Oh, they have been impleted later?
Yeah.
12, 13 and 14?
Yes.
Ms. Zairang Sangpui?
Oh, the Assam Rifle.
Assam Rifle.
And what about 8?
8 is also the
8 is the team
leader, SIT.
team leader, SIT, my lord.
So you are appearing? Or
Yes, my lord, I'll be on behalf.
Okay, Mr. Samuel, not only 1 to 5, but also 8 and 8, huh? Mr. Samuel submits that in pursuant to the last order, in pursuant to the order dated 28/7/2025, both the case diaries in respect of the instant case, first conducted by the state police initially, and the case diary with respect to the said case in relation to, a said case conducted by the SIT after the investigation was handed over to them was called for. However, when the matter is called up today, the case diary with regard to the case diary with regard to investigation carried on by the SIT is produced before the court. However, the case diary with regard to the investigation conducted by the state police could not be procured and placed before this court. Mr. Samuel as such submits that he may be allowed some time to place the case diary with regard to the investigation conducted by the state police. Full stop. He also submits that pursuant to the further investigation ordered by the learned CJM, which place?
Your Lordship, page 48.
No, place?
Champhai.
Champhai. The further investigation was conducted by the SIT, and according to his information, the SIT has submitted the report before the court. He as such submits that he may be allowed to place the said report also by procuring the same. Prayer is allowed. List this matter after 3 weeks, after the vacation. But then it will go on, no?
Yes, well. September.
After 2 weeks.
2 weeks will be more than enough.
After 2 weeks, on a date to be fixed by the registry. There are other matters, no? Yes.
Regarding item number 16, my lord.
1-6. Do it.
Of the hearing is, DMI Kashmir sir will have to head home due to some personal difficulties, so my lord, if the matter be taken up at 2 p.m. after lunch.
Today?
Yes, my lord.
At 2 p.m.
Yes, my lord.
Okay.
Your Lordship, this item 7, part 2. Your Lordship, tomorrow is it a division day matter, a bench?
Tomorrow there is a division bench.
So this matter may come up on Thursday then?
Thursday.
Item 7.
Item 7 may be called up on Thursday. Okay.
It's in the hearing.
Yes, and 16 today at 2 p.m.
Your Lordship, if your Lordship is not feeling well, it can be taken up.
No, I have taken appointment with the doctor of Alzheimer's.
Then we can
Let it
do
be in the
some
course.
other day.
No, I'll go in the afternoon. But I have chest pain, I don't know why.
Yes,
If your Lordship is
This
not feeling
normally
well,
never happens.
Yes,
let it be in the course list. Tomorrow, after, they can try and take it up on Thursday or whatever.
Thursday also.
Tomorrow, day after?
Yeah.
Okay. But it will be done, don't worry. It will be done.
No, but
Criminal appeal, I can dispose
we heard
it
your
of.
Lordship has a doctor's appointment. So let it be in the list. It can come up day after.
Day after. Or tomorrow I might have single bench after finishing. DB also, right? Then your matter will be on Thursday. But your matter I can take it up tomorrow. After the DB is over.
I left my senior, my lord.
Yes, Your Lordship, we will do this matter, item number 16, on Thursday. On
His
Thursday.
matter is also on Thursday.
Yes.
Tomorrow you ask your senior.
Yes, my lord.
Tomorrow it can be done if you want. And no other matters. Okay. Yeah.